Good evening to all of you. I'm Ashok Shetty, and today I'm going to speak on salaries and wages during the lockdown and a little general overview on the labor laws. Friends, all of you are aware that today we are on lockdown 4, and this is one of the most topical topics that is being discussed everywhere in the city, on televisions, and all over. And this is the only topic that is in everybody's tongues. Well, I'm going to speak to you today on the orders given by the Government of India and the orders of the Government of Maharashtra in relation to salaries and wages during the lockdown. You are aware that on 22nd of March, there was a Janta curfew. And after the Janta curfew, the Maharashtra government also declared a curfew, and immediately thereafter, a lockdown was declared. The government of Maharashtra came down with a order on the 29th of March and directed payment of salaries to workers without any deduction. The clause 3 of the Maharashtra Home Affairs order of the 29th March was under section 10(2)(1) of the Disaster Management Act 2005, and it provided for all employers, be it industry or in the shops and commercial establishments, shall make payment of wages of their workers at their workplace on the due date without any deduction for the period their establishments are under closure during the lockdown period. It means that all employers, be it industry or shops and commercial establishments. So this is not an exclusive definition. It is an inclusive definition, which means all employers, whether it is industry, whether it is shop, whether it is commercial establishment. And what they should do, they shall make payment of wages to their workers at their workplace on the due dates without any deduction. That means for the period their establishments are under closure due to lockdown. That if there is when there is a lockdown and the workers are not coming because of lockdown, obviously they cannot come, but they must be paid wages. This is the order of the government under clause 3 of the MHA order of 29th March 2020. Now, various state governments also issued advisories and orders under the National Disaster Management Act 2005 and the Epidemic Disease Act 1897. The National Disaster Management Act, I'll come to it, the definition of disaster, but that I feel may not strictly apply in this case of pandemic, where the Epidemic Disease Act would be more necessary. And they issued orders advising and directing employers that the employers are not to reduce the wages, retrench and terminate their workmen, but to pay them full wages during the period of the lockdown arising out of the outbreak. The Maharashtra government also on the 31st of March, just after 29th of March, the Maharashtra government also issued a GR on 31st, and the GR says, I quote, in reference to the workers and the displaced workers from the other state working in several businesses, shops and other institutions affected by the prior directions of the lockdown declared by the government of Maharashtra for the purpose of stopping the spread of coronavirus, and in light of the powers and functions of the Chairman State Executive Committee, Maharashtra State Disaster Management Authority under section 24 of the Disaster Management Act 2005, the following order has been given. Now, what is the order? The order says all workers, either on contract basis or outsourced workers, employees, temporary workers, employee or daily wage workers working in private organizations, industries, companies, shops, except essential services, etc., who have to stay at home at home due to the spread of COVID-19 virus shall be assumed to be on work. And these workers, employees, shall be given complete salaries and allowances to which they are entitled. So the government of Maharashtra also issues an order, a GR, a resolution, which clearly says that all workers, contract, whether they are contract workers, whether they are outsourced workers, whether they are temporary, they must be paid their salaries. Now, these orders they say always shall also apply to semi-government and industrial, commercial institutions, traders, and shops within the state of Maharashtra. In other words, the Government of India's orders, read with the Government of Maharashtra's orders, you are supposed to pay salaries, employers, whoever, there's no definition of employer given, but whoever is employing somebody is supposed to pay the salaries during the lockdown. Now, they do not distribute. Most of you are aware that under the Industrial Disputes Act, there is a definition for workmen under 2S. The definition of workmen is there, but the Disaster Management Act does not contain any such definition. And the workmen, supervisory, administrative, managerial employees and are excluded from the definition of workmen under the ID Act. But here, this definition, this workers definition does not deal with any definition. It merely says workers. Now, it does not say workers as defined under the Industrial Dispute Act. Therefore, in my view, everybody, whoever is employing anybody is an employer, and whoever is employed is an employee. So there is, even the definition of workman does not come. Therefore, any employer has to pay, whether it is maid servant or your personal driver, you have to pay the salaries. Now, this is an order under the Disaster Management Act, and it does not, if you look at the Disaster Management Act, it does not contain any specific provision empowering either the central or the state government to direct private employers to pay their workmen, employees, full wages during the period of the epidemic. The MHA order of 17th May, subsequently, the lockdown 1 was there, lockdown 2 was there, lockdown 3, and finally, when the lockdown 3 was to end on 18th of May 2020, the Government of India, Ministry of Home Affairs, passes an order on the 17th May 2020, extending the lockdown. And what does it say? Whereas, save and otherwise provided in the guidelines annexed to this order, all orders issued by the NEC, that is the National Executive Committee, under Section 10(2)(1) of the Disaster Management Act 2005 shall cease to have effect from 18/5/2020. In other words, the first order that the Government of India issued, that is on 29th of March 2020, directing payment of salaries to workers without deduction, Clause 3 especially, will go. That means the Government of India on the 17th of May passed an order which says that the earlier orders which were passed shall cease to have effect. Most of the employees were very happy when this order came on the 17th of May, but then their happiness was short-lived, because on the 17th of May, even the Government of Maharashtra passed an order extending the lockdown to 31st May. But on the 19th of May, the Government of Maharashtra passed another order revising the guidelines, and where they mention that it is further directed that all orders shall be, now there are two other paragraphs, this is the third paragraph, the last paragraph, which says that it is further directed that all earlier orders shall be aligned with this order and shall remain in force up to and inclusive of 31st May 2020. That means its earlier order, the order which was passed on the 31st of March 2020, in reference to workers, will continue. So as I said, the employers' happiness was short-lived when they realized that the lockdown will continue, and now with the lockdown, they were directed that all earlier orders also will continue, which means that their employers in Maharashtra will have to pay full wages till 31st May 2020, though the Government of India says that all earlier orders cease to have effect. So this is the position in the state of Maharashtra. Now coming to the disaster under the disaster management, it says a catastrophe, mishap, calamity, or grave occurrence. Now this could fall within this category. Now you read further, in any area, and now important is arising from natural or man-made causes or by accident. Now, whether COVID-19 is from natural or man-made causes. Now, we do not know whether it is originated from China, whether it is man-made in China. So far, there is no evidence. So, whether it can be called natural, it is not natural. Man-made causes or by accident or negligence. Nobody can say so far whether it was by accident it has come out or whether it's by negligence. So, it should be a catastrophe, mishap, calamity or grave occurrence in any area arising from natural or man-made causes or by accident, which results in substantial loss of life. All these things are okay. But this is doubtful. But it could fall definitely under the Epidemic Disease Act. But epidemic disease contains only 4 sections, nothing more than that. And only now they've added one more section where the doctors are protected. There is no definition of workmen, there's no definition of payment of wages. There's no requirement of payment of wages contained in that. Now, the order as it stands of the Government of India continues. So it may not be strictly legal according to you or me or many others, or the employers themselves may say it's not legal. But as on today, since the Government of India has passed the order remains, and therefore you are required to comply with it. If you don't comply with it, Section 51 of the Disaster Management Act 2005 will apply, which provides for punishment for obstruction. Whoever without reasonable cause obstruct any officer, now this will not actually apply to these employers. I'll go to the B. So we start with whoever without reasonable cause refuses to comply with any direction given by or on behalf of the central government or the state government or the National Executive Committee or State Executive Committee or District Authority under this Act shall on conviction be punishable with imprisonment for a term which may extend to 1 year or with fine. And if such obstruction or refusal to comply with the direction results in loss of lives, that means if a worker dies because of this or imminent danger thereof, shall on conviction be punishable with imprisonment for a term which may extend to 2 years. Therefore, as long as this order stands, this punishment is dangling on your head. Now, this has to be read with Section 58, because if you are a company, it's either a limited company or a partnership firm. Now, offences by company, where an offence under this Act has been committed by a company or a body corporate, every person who at the time of offence was committed was in charge of and was responsible to the company for the conduct of business of the company as well as the company shall be deemed to be guilty of contravention and shall be liable to be proceeded against and punished accordingly. Therefore, a person who was responsible to the company for the conduct of the business would be a person who would be liable to be prosecuted against, unless he proves that the offence was committed without his knowledge or that he exercised due diligence to prevent that commission of that. Now, second section is of the same Act, notwithstanding anything contained in subsection 1, where an offence under this Act has been committed by a company and it is proved that the offence was committed with the consent or connivance or is attributable. Not only consent, now even if consent is not there, attributable. By not doing anything also, sometimes you get, you are penalized. Or is attributable to any neglect on the part of any director, manager, secretary or other officer. Such director, manager, secretary shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Now, for the purpose of company, also includes the firm. So it need not be a company registered under the Companies Act. It can also be a company or partnership firm. The firm always means a partnership. And a director, which is mentioned in that section, will also mean a partner of a firm. That means even partnerships are covered. Only thing is, proprietor is not mentioned. But when the word employer has been used, no definition has been given. So therefore, in my view, even a proprietor would be as much liable as a director or a partner of a firm. Now, only Industrial Disputes Act, which is a special enactment, deals with the right of an employer to lay off, retrench due to inability to give work on account of natural calamity. Now, all employers contend that during the lockdown, I cannot get any work done from my employees. So I can lay them off, because the Industrial Disputes Act, the definition of layoff provides that if it is a natural calamity, I can lay off the employees. The Disaster Management Act or the Epidemic Act has no such provisions on this subject. So therefore, the ID Act providing for layoff and retrenchment is the special enactment, and that has to be followed according to me. Now, it is governed by another special enactment, and that is the Payment of Wages Act. Now, there is no provision for payment of wages in either of these two acts, either in the disaster management or in the epidemic. Now, this is again governed. The payment of wages governed by another act, the Payment of Wages Act. Today, as on today, this along with the Minimum Wages Act, Payment of Bonus Act, and Equal Remuneration Act will be replaced by the Code of Wages. So that way I'll come to it when I speak to you about the Code on Wages. But these are the only two enactments. The Payment of Wages Act provides that permissible deductions from wages for absence from duty. If a person does not come on duty, you are entitled in law under the Payment of Wages Act to deduct the amount of these wages from his salary. And if an employee is absent from duty during lockout, under the Payment of Wages, I am entitled to deduct. There is no provision for payment of wages in the Disaster Management Act or in the Epidemic Act for absence from duty. Then Section 72. Now this may be quoted. 72 of the Disaster Management provides that it will have an overriding effect over any other law, which obviously is in case of inconsistent. Notwithstanding any inconsistency, if it is inconsistent with any other law, the Disaster Management Act will prevail. But it has to be inconsistent. Since the Disaster Management Act and the Epidemic Disease Act, there is no provision for payment of wages, where is the question of inconsistency? Therefore, the ID Act and this thing are special enactments on the subject, and therefore they will prevail over the disaster management, which does not contain any such provision for non-payment of wages or payment of wages during the. Another principle which has been flouted, the principle of no work, no pay. Now, the Supreme Court, 2 or 3 decades ago, in the case of Bank of India versus Kelawala, had given this judgment which says that no work, no pay. Employees had gone on a strike. After coming for work, reporting for duty, signing the muster, they went out for about 1 or 2 hours to shout slogans. And the Supreme Court said pro rata wages can be deducted for those 2 hours because they did not do work. So no work, no pay. This principle has also been flouted or given a go by. Now, you are aware, most of us who are in the field are aware that petitions have been filed in the Supreme Court. Now, these petitions are filed under Article 32. Now, Article 32 also provides that if it is in case, now at Article 32 of the Constitution, this has been filed because it's a matter of in that 1 minute. It's a constitutional right which they have invoked. Now, what are the points that have been taken up? Then is a petition can be filed before the Supreme Court on a policy matter. Now, this they claim is a policy matter, and the Supreme Court has told them that if it's a policy, please explain and set out your policy. Now, and normally a policy cannot be challenged or it is not subject to judicial review unless and until it is unilateral, arbitrary, in gross violation of the principles of natural justice and contrary to public policy, as well as it is contrary to the existing statutes, namely the Industrial Disputes Act, the Payment of Wages Act, and on the subject, the provision relating to layoffs and retrenchment, and is patently beyond the powers vested in the government of India as well as the state government under the Disaster Management Act and the Epidemic Disease Act 1897. The orders are also unreasonable, irrational, capricious, and contrary to Article 21 dealing with the fundamental right to life of the employers. Obviously, you can't deprive them. Ultimately, if he goes on paying wages without any work in his establishment, he will end up without any money, and his survival will be at stake. It is also contrary to Article 308, Now, this 300A was brought into the Constitution by an amendment in 1978, when the fundamental right, when the right to property was no longer a fundamental right. The right to property was brought in as a constitutional right. It is not a fundamental right, but it is a constitutional right. Now, in terms of which no person can be deprived of his property, save by the authority of law. Now, here is a case where my entire earnings, profitability, plus if I have to keep on paying the salaries, my entire property is going to be deprived without any authority of law. Now, as far as the money is concerned, why should an employer pay? Is the question that an employer will ask. Entire payment. And there is a provision, there are funds which are available. And till now, we have not heard anything about those funds. Under Section 46(1) of the Disaster Management Act, the central government has constituted a National Disaster Response Fund. Now, this is what for meeting any threatening disaster or disaster and response relief and for rehabilitation as per guidelines. 46(2) of the Disaster Management Act, there is a National Disaster Response Fund is to be made available to the National Executive Committee. For what? To be applied towards the meeting expenses for the emergency response, relief and rehabilitation. The present situation can be applied if it is a disaster. Section 47 provides for a National Disaster Mitigation Fund. Now, this is for projects exclusively for the purpose of mitigation. And 48 provides, Section 48 provides that the state and the district shall also have a district response, the disaster response and disaster mitigation fund. That means state disaster response and mitigation fund, district disaster response and mitigation fund. So there are 1, 2, 3, 4. Well, I'm sorry, 1, 2, 3 funds into 2. One mitigation and response. So there are 6 funds, 2 with the national, 1, 2 with the state, and 2 with the district. Besides that, you're aware that the PM relief fund on all such occasions where the Prime Minister's relief fund is utilized. But a new fund has been created, the PM Cares Fund. This a lot of persons have contributed also. People, it is also said that it will be treated as under CSR, they will get the benefit. People have contributed in crores. The Prime Minister's Citizens Assistance and Relief in Emergency Situation Fund. This has to be used in an emergency only. Entire fund has to be used. There is no response whether this fund has been utilized or not. Because it has to be utilized now only. It cannot be utilized subsequently for some other thing. It will amount to appropriation for some other fund. It has to be utilized for the emergency situation only because this has been created for this purpose. And contributions have been collected in the name of COVID. Now, so therefore, friend, why should private employers be made to bear the burden of wages of the employees during the lockdown period without work when the obligation is on the government, as in other countries, which have social security schemes? The West, Europe, as well as America, Australia, New Zealand, Japan, they have social security, where a man, if he loses his job, he registers for welfare. They call it dole. In fact, US did not declare this thing because they felt that if lockdown is declared, everybody will line up for welfare. Whereas no such amenity is there for us. Therefore, we could declare a lockdown without bothering that people will stand in queue for welfare. What happened subsequently is a different matter. But in America and other countries, now for instance, in Australia, I am told that the companies have been told, you continue the employees, don't sack them. We will pay you a large portion of their salaries. With the result, the joblessness has been saved, and people are just getting the money, their salaries. So Australia has been able to control, New Zealand has been controlled, Taiwan has controlled, but in our case, the fund, I do not know why employers have to pay. I could understand if an employer has to pay 1/3, employee also has to bear the burden. why should he not bear the burden without this thing, without the deduction? In fact, he gets, because of the COVID, he gets more amount because there is no deduction. Subsequently, the Provident Fund deduction has been given, but that is a subsequent affair. Now, I would say that 1/3, 30% employer could pay, 30% workmen could bear the burden, and 40% the government could bear the burden from the resources that they already have, or what they have collected. Petitions have been filed in the Bombay High Court also, wherein Allied Components versus India now in the Bombay High Court, Justice Guge has passed an order sitting in Aurangabad bench. This permits employers to deduct wages if the employees do not report for work in areas where the restrictions are relaxed after the lockdown. So this is one positive statement which has come. After the lockdown, they do not report for duty, then you can deduct their wages. But we declined to interfere with the MHA order on the ground that the Supreme Court is dealing with this similar cause of action, and therefore the Bombay High Court rightly decided not to deal with it. But on the contrary, he said that we would expect, whether it's an order or a sugar-coated order, expect the petitioners to pay the gross monthly wages to the employees, save and accept the conveyance allowance and food allowance, if it is being paid on a month-to-month basis in cases of those workers who are not required to report for duties. So he says, would expect the petitioner. Now, question of conveyance allowance, and this is aware of the Surya Roshni case, which says that if an allowance is paid across the board, it is basic wages, and for which PF has to be deducted. Therefore, it is wages. Now, unless the company is paying conveyance for them to come to office, then here the question of coming does not arise. And once they come to office to have food, here the question of coming to office doesn't arise. Therefore, there is no question of conveyance and no question of food. But if it is something which is paid across the board, even when a person is on leave, then it becomes a part of his salary. So from that point of view, even this would be treated as wages subsequently. Now, Kerala High Court has stayed an order issued by the Kerala government to defer the payment of salary. 50%, they had said 50% salary will be deferred. Not paid, but deferred. Will be paid later. But Kerala High Court has stayed that order. In fact, 2 days ago, day for yesterday, Bombay High Court, Justice Katawala has passed an order on 27th of May in respect of contract workers, frontline COVID workers who are working shoulder to shoulder with the state government employees, with the BMC employees in the front line as COVID workers. They are contract employees, and therefore they are not paid the wages which others are paid, with the regular employees are paid, the allowances. Therefore, plus there is no insurance guarantee, insurance is there. So therefore, the court ordered that they should also be paid on the basis of what the other regular employees are being paid, because they are also putting themselves to the same risk. And again, the principle is there on equal remuneration, principle of equal pay for equal work is there, and they are working shoulder to shoulder, they are also entitled. And therefore, this order has been passed on the 27th of May. Now, writ petitions have been filed in the Supreme Court by Nagarika Exports. First, that is the first petition which was filed. Subsequently, they have withdrawn the petition, saying that there are other petitions which have come. I don't know what is the reason, but that ought to have been continued actually. Karnataka Packaging, Ficus Pax, now this is the main petition that is going on. Plus, the Ludhiana Hand Tools Association have been filed for quashing and setting aside that MHA order of 29th of March. Now, apart from what they have said, the Ficus Pax as challenged, apart from the constitutional validity contending that the MHA orders were arbitrary, illegal, irrational, unreasonable, contrary to the provisions of law, including Article 14 and 19(1)(g) of the Constitution. They have said that both these will not are illegal. Now, Article 14, as you are aware, the right to equality, and 19(1)(g) says to practice any profession or carry on any occupation, trade, or business. Now, that is the Article 19(1)(g). That for an employer to practice any profession, that is one of his fundamental rights, and that is being violated. Now, it also says that the MHA order would make an otherwise stable and solvent industrial establishment, especially MSME, that is a micro, small scale or medium enterprises establishment, into an insolvent and loss of control of business. So then it is also contended that the MHA order of 29th March 2020 under the Disaster Management Act is violative of Article 1490 and 265. Now, that is 265, Article 265 says that taxes not to be imposed save by the authority of law. No tax shall be levied or collected except by the authority of law. So this amounts literally a tax being imposed on us without any provision in law. No act of parliament is there, just an executive order. And Article 300, it should be 300A of the Constitution, also says, as I said earlier, the right to property. Now, this is by virtue of a 44th Amendment, which was passed in 1978, that no person shall be deprived of his property save by authority of law. So, on these two grounds, it has contended that they should be struck down. Now, this has come before Justice Ramana, Justice Sanjay Kishan, and Justice B.R. Gawai from our Bombay High Court of Court on the 27th of April 2020. The central government was given 2 weeks' time to put. They said it is a policy matter and court should not interfere. So he said, the court said, you put the policy on record, file your reply. Put your policy means the court has a right. If the policy, it may not be, the policy cannot be interfered with normally. As I said, not subject to judicial review. But unless, if it is capricious, unreasonable, against public policy, it can be gone into. It can be struck down. So, but no stay or interim relief was granted by the Supreme Court. So as on today, as on that day also, the order of the government of India as well as the government of Maharashtra continued. Now, National Association of Journalists, now, even in the media line, media houses started removing people, started giving them the pink slip, with the result, and some of them didn't pay wages, job losses. So the media industry was also relying on the MHA order. The journalists. So they filed a petition in the court. Supreme Court has issued a notice to the media houses and asked the petitioners to join the central government as well. Now, the contention in that would be that media houses are private enterprises and therefore no petition will lie against them. But making the central government a party, they can maintain that petition. Now, the Supreme Court on the 30th of April 2020, in the Twin City Industrial Employees, from our Bombay only, to Mr. Talreja, D.D. Talreja, one of our senior advocates, filed a petition to the Supreme Court on 30th of April 2020, refused to intervene and grant stay to the MSME industries on the operation of the order, the full wages. Then Instrument and Chemicals also filed a petition along with 10 others led by this company, and they contended that they are entitled to lay off and retrench this thing in terms of section 2KK, 200, 2KK layoff, 200 retrenchment, and 25C25 the permit under the ID Act. There's a chapter 5B. Contending that because of natural calamity, we are entitled that under section 25M of the ID Act, there is no bar to lay off or to seek permission of the government if such layoff is on account of a national calamity. The government cannot legally override contracts between employers and contractors for contractual work. Here they say the employees also should be paid. Now, the obligation to pay wages during the lockout is on the government and not on the employer. Now, these are the contentions that they have taken. The orders are contrary to the Article 300, which I have already mentioned about. So, now, second is by way of enforcement. Now, here again, one of the contentions that they have taken is that by way of enforcement, the orders, the government is forcing the MSMEs to bear an expense which otherwise it should not. In other words, it's compelling them to bear this expense, which otherwise it's the government's obligation. Now, the Supreme Court has again granted time to all these, in respect of all these petitions to the government to file their reply. In the meantime, some prosecution started in, I think it's in Ludhiana, where they said they prosecuted some of the employers. And therefore, the Supreme Court directed the government not to take any coercive action in the meantime for non-compliance of the MHA order. And there was a hue and cry saying that the Supreme Court has quashed this thing, which is not so. The present status is Supreme Court has only granted time to government to file reply, and no coercive action to be taken. That is the position today, as of today. There was this that the order has been, MHA order has been quashed and set aside, which is not so. It was reported in the section of the media. Now, there are a lot of during this period, a lot of contracts are there where principal employers are there who have entered into with the service providers, which contain a force majeure clause. Now, what does force majeure means? An event, a circumstance which is beyond the reasonable control of a party and which makes a party's performance of his obligations impossible. This is the position. Now, today, if there is a contract to provide contract workers to your establishment, and because of the lockdown they are not able to do so, it will come within the purview of force majeure. Similarly, there are hoardings which are put up, and people say that we are not able to this because government is telling us to put only this Corona 1916 telephone number on all these hoardings. If you see around the city, all the hoardings contain. So they say we cannot pay you the normal charges that we pay for the hoarding. So because of force majeure. So that concept, that clause is there in most of the agreements. But if it is not there, then the doctrine of frustration will come in. The law recognizes that without default of either party, a contractual obligation has become incapable of being performed because the circumstances in which the performance is called for would render it a thing radically different from which was undertaken by the contract. So if that obligation to perform cannot be performed, that is the principle of frustration, which is contained in the Contract Act. Section 56 of the Indian Contract explains the supervening impossibility leading to the doctrine of frustration. Now, coming back to section 51. Today, if you read section 51, it provides for penalty in case of non-compliance. You have seen it earlier. It says it starts with anyone who without reasonable cause, a person shall be punished with imprisonment or fine. Now, the key words are without reasonable cause. Can financial inability to pay wages be a reasonable cause? This could be a window for some employers who are not in a position to pay salary to their employees because they themselves are from hand to mouth. So this probably could be utilized, but that does not guarantee that you will not be prosecuted unless the Supreme Court quashes the order. So this could only serve as a window for you to move out. Section 58 also that we have dealt with. Now, so this is as far as the Supreme Court cases are concerned. Now, the government has come out with the Provident Fund thing, where the Provident Fund has been given for the purpose of giving liquidity to the employer and employees. Now, what it has done is, instead of paying 12%, you pay now 10%. Various issues arise here. If an employee says, no, you pay 12%, is an employer bound to pay 12? No, because this is a benefit which is given both to employer and employee. And the purpose is to see that both of them have liquidity. So even if the employee says you pay 12%, it is not necessary that the employer has to pay 12%. Employer can pay 10%. So therefore, but however, as far as CTC is concerned, there's a different thing. The employer will have to bear the burden of 12%. Now, that is as far as the benefit that is given under that 20 lakh crore package. Now, the new concept that has been floating around all over this thing is the concept of work to home. My friend Advocate Vijay Vaidya has dealt with exhaustively on a webinar earlier, and I have taken some points from him as well. In India, work from home concept existed in our villages. Niche dukan, upar makan. You are aware of that. Or makan aage dukan, piche makan. So most of these cobblers, goldsmiths, then other karigars, as you say, all these people today who are migrants used to do their trade at home. If he was a cobbler, he will stay at the back and do his work in front. If he was an artisan, he would work in front and stay at the back with his family. But the Industrial Revolution in England changed everything, which resulted in the establishment of factories, methods of mass production. And with the result, these factories were established in cities. And what they did was, the people produced goods in large quantities. With the result, it was cost effective. And with the result, most of these artisans were lost their things. And ultimately, they had to move to the cities, and they migrated to the cities and started working in factories. So that work to home concept is a concept which is very old in India. But now this is a concept which is being used in other developed countries, which probably never had what we in our culture had in the past. But various problems now keep coming up, because most of our laws, before formalizing this complaint, we must try to tackle what are the problems that are going to come up. Because most of our employment contracts are establishment centric. They presuppose that an establishment. And like, for instance, any misconduct is committed, it has to be committed on the premises of the establishment. The judgments which are there which say that if it's committed outside, it has nothing to do with employment. So now question is, all these issues will arise. Some of the issues which I've listed out versus hours of work. Work from home, does it mean that he has to work 24 hours? Any time of the day, he can get a call from his office and say, what are you doing now? 24/7, no holidays, Saturdays, Sundays, if there are. Next is fixing of flex time and core time. Now, what is flexible time? Flexible time means your working time. This concept was there earlier also. Some companies used to start early in the morning at 9 o'clock when the rush is not, 8 o'clock when the rush is not there. And they used to leave because 6 o'clock or 5 o'clock, if the rush is there, they used to leave by 4 o'clock. So with the result, they don't get into the traffic mess. So there's a flex time and a core time. But all employees have to meet between 2 and 4 or 1 and 2. Means some core time was always there. So that also would have to be done. At what time everybody should come on the Zoom for a meeting so that they can all come together. Now, next is, now if things have to be signed and all these things, of course, digital signatures are there. But nevertheless, we need to see the papers and sign some documents and all this, for which office visit would be also necessary. Next is transfers. If a man has to be transferred from one department to another, one department is all right, one location to another, like from the man is in Bombay, he has to be transferred to Ratnagiri. What do you do? Or to another state, or for that matter to another sister company. So how do we tackle that? Then the issue of privacy is there. Disturbance of the family. Whenever the work to home is going on, today you have a paucity of space at home is there. Some of us have smaller houses, others have bigger houses. Bigger houses, they can have a separate dedicated room to work. Whereas those people who do not have bigger houses, people in Bombay, paucity of space is there, small houses, pigeonholes rather we call it. So in such cases, how do they tackle? Other issues are teamwork, interaction with colleagues, and the boss, interaction with the boss, the chain of command with my subordinates, how do I, this thing, how do they report to me? Then the important part is misconduct. What are the misconducts that you can commit when you are working at home? Insubordination, fraud, all these are misconducts which are listed in the standing orders. So that would also require a revision. Then infrastructure facilities. Now here itself we've seen that the infrastructure is not that good, in the sense that my internet connection is not that well, and because of which probably my communication is not so if I don't have a proper infrastructure, don't have a proper computer, don't have a good internet connection, probably work will have to be done to see that the infrastructure facilities at home are also matching to the needs of the company. And therefore, new rules will have to be framed. And nowadays, the SOP has become a famous terminology, which is being used by most of the people, standard operating procedures. Therefore, standard operating procedures would have to be in place. besides several other things which we'll have to go in. Now, these are the issues that are there as far as payment of salary is concerned, and the COVID-19 challenges that have come before us. Now, with this, I will now come to just touch upon, in fact, time is short, but we'll just touch upon the overview on the labor laws. Now, what are the labor laws that are there? There are at least 40 labor legislations that we have in our country. The government of India, and very rightly, has tried to bring on everything together in the form of 3 labor legislation. One is the Code on Wages, the Code on Industrial Relations, and the Code on Social Security. Now, the Code on Wages 2019 is an act which got the President's assent on August of 8, 2019, after it got a nod from both the Houses of Parliament. It has replaced 4 labor laws. First is the Payment of Wages Act, the Minimum Wages Act, Payment of Bonus Act, and the Equal Remuneration Act. So these 4 acts are replaced by this. Now, as on today, the payment of all these acts are still continuing because the Code of Wages has not yet come into force. So it will come into force on a day when the government issues an order. It has come into force from today. But it is probably waiting because the other 2 codes are not yet the same. The other 2 codes are the Industrial Code on the Industrial Relations Code 2019, which was introduced in the Lok Sabha on 28th of November 2019, and which seeks to replace 3 labor laws: Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. The next one, that is the Code on Social Security, is a more dense, which was introduced in Lok Sabha on December 11, 2019, and it has replaced 17 labor laws. Some of them are small, 9 major labor laws, and others. So total about 17 labor laws it is supposed to have replaced. Some of them like Employees Provident Fund, Employees State Insurance, ESI Act, Maternity Benefit Act, Unorganized Workers Social Security, and many such provisions have been, acts have been replaced, put together. Now, in the Code on Wages, I would like to say that the definition of wages has, there's an exhaustive definition, and the definition is such that probably will give scope for a lot of interpretations, and our labor lawyers will have a lot of work. This is what I feel as far as due to this change. In fact, even a domestic worker will be included in this. Manager also would be included. Manager, administrative officers, administrative managers, all would come within the definition because there are 2 definitions. One is the definition of employee, another is the definition of workman. So anyway, we'll have to sit and study that because it's a new act and a lot of new things, new thoughts have gone into it. But as far as the other 2, Industrial Relation Code, which has not come so far, it is still pending, and the Code of Security, but both of them have been referred to a standing committee on labor headed by Mr. Bharat Tuhari Mahatab, is a member of parliament, who has invited suggestions and this. And our Labour Law Practitioners Association, headed by Vinay Menon, has come out with this with a seminar where we had discussions and put up suggestions which have been sent and sent to the minister, to the Standing Committee on Labour. We hope some of those suggestions will be incorporated because our apprehensions with the labour practitioners will definitely be much more solid than what has been done by others. So we hope and trust that the new format which comes up will be something which will be more palatable. Now, with this, I thank everybody for having listened to me patiently. I must thank Siddharth Morarka for inviting me to share my views on this webinar. And I also thank Rita Joshi, advocate who is my junior, who has been my junior, and now, of course, she's a senior herself, and advocate Neeraj Shah for this, and also Gaurav Shetty for all the technical help that he has given me as far as my presentation is concerned. Thank you very much. And with this, the question answers can be put forward. Thank you very much. Let's see whether the report has come. What is it? What is charming?